And I'm seeing this movement towards a sort of truth skepticism when it comes to free speech issues. On the left, it's a little bit more obvious. It leads towards these statements like anybody can be any sex is changeable, failure to protect unborn life, this extreme relativism where what you say is true for you, what I say is true for me. On the right, though, I do think it's still present, though more subtle. And what it leads to is a failure to address the actual moral and scientific merit of those same types of things. Let's say the government wants to say that we hold these truths to be self-evident. All men are created equal, that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. And those words from the Declaration, if we reach this absolute truth skepticism and refusal to make any statement about what is right or wrong, those words wouldn't be constitutionally protected, even though they form the foundation of our country today. If we reach the point where we bar all orthodoxy from our social virtues, we will end up with no social virtues.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week, we're covering the reemergence of the National Religious Broadcasters lawsuit against the IRS that we spoke about quite a bit last year and thought was over, but now it is not. This is a case about the Johnson Amendment we'll get to in just a moment. Then we'll go to the Ninth Circuit and talk about a case involving a social worker in a school who was fired for affirming the reality of God-given sexual identity in a pretty modest way, by the way. And then we'll finish with a settlement agreement between the pro-life activist Mark Houck and the DOJ, which you probably remember from now 3 or 4 years ago. So a couple of things that have come back from the dead that we'll get to today. But let's start in the district court in Texas. This is really interesting. I'll give you some background reminder of what this case is about because there's not too much that's new other than that it's still live again. So this is the National Religious Broadcasters along with a few other plaintiffs. I believe there was another nonprofit and there were a couple of churches on the original lawsuit. So there was a lawsuit where they sued the IRS when it was the IRS still under the Biden administration. And the claim was that the Johnson Amendment was unconstitutional. If you need a refresher, the Johnson Amendment is the part of the tax code that's been there since 1954 that prohibits tax-exempt 501c3 organizations from engaging in any political campaign activity, which would include the endorsement of or opposition to any political candidate. That was the center of this challenge. The lawsuit from NRB and company claimed that the Johnson Amendment violates the rights of religious organizations, including their First Amendment rights to freedom of speech and free exercise of religion. So, after the Trump administration took office, it changed the posture of the case. The IRS claimed that they weren't going to enforce the Johnson Amendment, at least in certain circumstances, and they entered into a consent agreement with the National Religious Broadcasters and the other plaintiffs. We covered this a lot. I wrote a piece on it, I think at First Things Magazine last year. I noted in that piece because there was a lot of, I think, slightly exaggerated or misleading headline generation going on. So this case means that churches can now endorse political candidates line was not quite right. And practically, I get what was going on, but the settlement agreement was very technical. The agreement explained that the IRS doesn't consider certain forms of political expression to be political activity or endorsement of a candidate. So if there were certain communications that happened in connection with religious services through the usual channels of communication, so think sermons from the pulpit, communications that are normally part of the religious service, those were not considered political endorsements that would violate the Johnson Amendment. But that's not the same as a church leader maybe holding a political rally or endorsing a political candidate on behalf of the church. So it was a modest thing, but the long and short of it was pretty clear that the Trump IRS was not really interested in pursuing this and going after, churches for saying things about political candidates. And that's basically where the case stood until just a few weeks ago. Then the judge in the Texas District Court on March 31st ruled that the court lacked jurisdiction to enter the settlement agreement due to the Tax Anti-Injunction Act and certain restrictions in the Declaratory Judgment Act. And the reasoning was that generally federal courts are prohibited from issuing any kind of order, including apparently a settlement agreement, that would restrain the assessment or collection of taxes, which I suppose this does because the settlement agreement saying that certain organizations can do certain things and not be taxed. They can still keep their 501c3 status. So Because of that, the judge dismissed the case without prejudice, so this can be refiled. Um, it leaves us in a really interesting situation because, on one hand, I don't really think this is a crazy reading of those statutes. It is pretty tight what courts can do about tax collection or assessment. But like I said, this creates a really strange situation. And so it's unclear how exactly this will proceed. I have some ideas about how it should proceed, but that's a different question. Um, Practically, like we said, the Johnson Amendment is almost never enforced. I think there have been like two, maybe three examples of actual revocation of 501c3 status of a church for endorsing a political candidate or engaging in campaign activity in the 70 years that the law has been on the books. And one of them was like a test case. Or there was that church that took out a what was it? It was like a one-page ad, and it might have been the New York Times basically saying that if you vote for Hillary Clinton, you're going to hell. That might have been a little bit of an exaggeration, but that was basically what they did. And it was done on purpose to try to get the IRS to actually enforce the Johnson Amendment and set up a challenge case. But they almost never do it. So how you actually get standing to take on and repeal the Johnson, or not repeal, but overrule the Johnson Amendment as unconstitutional is it's tough. I mean, I guess NRB or another religious party, a church could forego nonprofit status, actually pay taxes, and then have standing to sue as a taxpayer. I don't know, saying that they're wrongfully excluded from C3 status. Or you can just push the limit, like the Clinton anti-Clinton ad, right? You could openly just engage in political activity as loudly as you possibly can in the hope of attracting the IRS to step in and revoke your C3 status so you can set up the lawsuit. But as NRB's general counsel noted in an article I read about, I think it was in the National Catholic Register, but the council noted, a nonprofit shouldn't be required to actually risk its tax exempt status in order to challenge this law under the First Amendment. So it's it's kind of a bad place to be in. I think the Johnson Amendment is the argument that it's facially unconstitutional is pretty strong. And people have been arguing about this for decades, but because it's so seldom enforced, it's really hard to find a litigant with standing to actually sue and deal with this case on the merits. Um, the obvious answer is the proper avenue is simply for Congress to do its job here and repeal the Johnson Amendment because I think it's probably unconstitutional. There have been several efforts. There was a prominent effort in 2017 to repeal the Johnson Amendment that died. Last year, when this case was going on, Senator Lankford and Representative Mark Harris introduced that Free Speech Fairness Act, but it hasn't moved since last June, I think. I don't think it would be a stretch to say that congressional repeal is probably pretty unlikely. Um, so I don't have much of a conclusion. It's interesting. We thought this was a dead case, and we're like, okay, IRS isn't going to touch this, and we'll see what happens to the Johnson Amendment itself. But this makes it live again. I think it's pretty likely that this will be appealed to the Fifth Circuit. I believe NRB already announced that they intend to appeal to the Fifth Circuit. So we'll keep you updated on further developments. And then just a note, too, to our listeners who care about this type of issue and how the IRS treats religious organizations, we will have a guest episode coming in the near future with a tax attorney and a friend of the Napa Legal Institute who will dive deep into this Johnson Amendment issue that should be coming out in the next couple weeks. So, Joseph, any thoughts?
Yeah, I'm curious to see where this case actually goes. Like you mentioned, Frank, the trial court's opinion looks kind of like a tight reading of these two statutes. It's the AIA and the DJA. Basically, they say you can't file a lawsuit that would prevent the collection of taxes. But those two laws actually, they do give some very narrow, but there are avenues for this type of challenge. The first is a refund suit. So basically, if somebody goes and loses their C3 status, they're then able to sue afterwards. But they have to actually lose it first, like you said, and they have to actually pay the tax. And that's like you mentioned, that article in the NCR, that doesn't really make sense for a C3 to have to lose their status to do something that looks like a constitutionally protected right. There are also a couple DC that it, for some reason, gives three specific DC courts that might be able to hear this type of challenge, but again, it's kind of a narrow statute, so it's hard to see. So I am curious if this dismissal without prejudice stands at the next level, if they'll just like go file in one of those other three courts. But yeah, not a whole lot to add to the substance here because it's something that we'll have to keep tracking. Like you said, the Johnson Amendment looks to be facially unconstitutional, denying a forum to challenge an unconstitutional law, even if it touches on tax-related issues, seems kind of counterintuitive and strange. But the simplest way really is congressional action, but that might be a little bit non-viable right now. So really, if nothing else, I'm just curious to see what happens next in this case, and I'm excited for that guest episode to come out, and I'll kind of keep reading things, and we'll keep you guys updated too. Awesome. With that, we'll head on to our second update, where the Ninth Circuit recently heard oral arguments in a case involving a social worker who was fired for failing to remove books that affirmed the reality of God-given sexual identity. So for the facts, this man named Rod Tice is a social worker at an Oregon educational institution called Intermountain. They partner with public school districts. And Rod administers standardized tests to evaluate kids' intellectual and social and emotional needs. The brief, and this will come up later, notes that his role is important but limited. He's not a counselor. He's not giving advice to kids. He basically just administers standardized tests and then reports on the results. Um, like other stuff at this group called Intermountain, Rod decorates his office with personal items. They're allowed to use pictures of families, things that have religious significance to them, that sort of thing. A lot of employees put out very ideological decorations like pride flags, BLM posters, other clearly politically motivated things like that. I think some teacher had an Obama poster in their office. And Rod's office, while mostly bare, he eventually put up these two kids' books that encourage students to embrace who they are and, quote, prize the way that God created them. That's from the case brief. These books are called He is He, She is She. Eventually he added the very famous Johnny the Walrus from Matt Walsh. And these books are very positively framed. They basically say, like, if you're a boy, God created you this way and he loves you and you're amazing. It's all a very positive thing. There's nothing explicit. There's no attacks or anything. He also, like I mentioned, doesn't use them in his job at all because he's not a counselor. He's not giving advice to kids. He basically just put them up on his windowsill because he thought that they were important and that they showed his religious belief that God created sex immutable and it's a gift. Eventually, however, one of God's coworkers complained about the books. No student ever really talked about it. No parent complained or anything like that. One of his coworkers complained about these books. That complaint eventually led to Rod being investigated and fired. Rod filed a lawsuit claiming that his rights to free speech, free exercise, and due process were violated. He had a partial victory at a federal trial court, which we'll get into, and recently his case just had oral arguments last week at the Ninth Circuit. So I want to focus on his free speech claim, both because I think it's important in this lawsuit and it gets a little bit to, I think, something broader going on in not only the conservative legal movement, but also just jurisprudence kind of generally right now. So I mentioned he won a partial victory at the district court. The judge there ruled that Rod could display his books only when no kids are in his office. He could display them whenever he wanted to, but as soon as a kid stepped into his office, the court said that is government-sponsored speech at that point because a student could, quote, view it as being promoted by the school. Once his speech of displaying these books passively behind his desk and not opening to anybody becomes visible to a student, it's government speech, therefore it's no longer protected. I think some of the issues with that kind of reasoning are pretty obvious. We've talked about this a bit before, but there are serious practical and constitutional issues with that type of reasonable observer test. Legally, it looks a lot like the Lemon test. For anyone who's unfamiliar, that's comes from a case in the 1970s. It's an Establishment Clause thing. And basically the precedent set there was that if a reasonable observer could mistakenly believe that speech is sponsored by the government, that could constitute an Establishment Clause violation. That test was kind of done away with throughout a series of different cases. It was most recently disavowed in Kennedy. That was a case where a public school football coach would pray after football games. And in that case, the court said, we have since long ago abandoned Lemon and its reasonable observer test offshoot. So that type of test where it says, does somebody, even if they're wrong, could they reasonably think that this speech is sponsored by the government? It doesn't make any sense. It's not in line with what the First Amendment actually does on speech or Establishment Clause jurisprudence. And it can create really conflicting decisions between different judges. One judge might think that a reasonable observer might think one thing, another judge could be totally different. And there's really no basis in the law for that type of test. And just more broadly, kind of stepping aside from that type of test, Intermountain's actions against Tice were very clearly motivated by a pro-transgender ideology and were very clearly viewpoint-based discrimination, which is very, very much against the First Amendment that's been ruled time and time again. So Intermountain's leadership said that they wanted to maintain a neutral environment in their schools and offices, and that Tice violated its speech code, which bans, quote, bias incidents. Now, these bias incidents are defined as hostile expressions of animus toward another person related to the other person's perceived gender identity. Like I mentioned, the books that Tice put up are very positive, and he only showed the covers. He didn't actually really open them up during these sessions. They're very positive. The books say, quote, girls can do anything, quote, boys can do great things. Everything's framed in a very positive light. It's clearly meant to encourage kids that are whether or not they're struggling with gender identity, but just to encourage kids to appreciate that God created them in this beautiful way and that they are amazing how they are. There's no attacks against people one way or another. It's all very warmly framed and warmly put. And as for maintaining a neutral environment, that's a total farce in this case. Like I mentioned, other staff had pride flags. They had the school and other offices had books that were pro-LGBT and actually quite sexually explicit. Some of the things in there are not something that any kid should read, especially not when it's something from a transgender or a homosexual bent. I don't know. It was very clear that there's no attempt from the schools that Intermountain partnered with or Intermountain themselves to actually maintain neutrality. Very clearly partisan, and then there were no action taken against those other partisan displays. And in fact, just kind of this adds a little bit of color to it. During her investigation of Rod, one of Intermountain's directors told him that he could only put up books that, quote, don't display a view that might be contrary to someone else's beliefs or views. And this is after asking him, what do you mean by truth? Kind of a very Pontius Pilate-esque question. Quid est veritas. And just that concept that you can't display a view that might be contrary to somebody else's beliefs. Everything might be contrary to somebody else's beliefs. That's such a broad kind of statement that it's very clearly unconstitutional. Someone could think that 2 + 2 does not equal 4, and if I say it is, well, that could maybe possibly contradict somebody else's belief. And again, that wasn't actually carried out in any other classroom but this guy's. And it actually wasn't a classroom, anybody's office but this guy's. So just based on the school's conduct, this was very clearly viewpoint-based censorship, and further, Rod's speech, even when students are in that room, isn't government-sponsored speech under these tests. It's very clearly private and should have been protected. And I want to close kind of taking a little bit out of this case, but just with some broader thoughts on where we're heading with our free speech jurisprudence. Frank, I imagine you'll have some more thoughts on this as I previewed offline. And I'm seeing this movement towards a sort of truth skepticism when it comes to free speech issues. We can't ultimately say under this kind of movement that I'm seeing that anything is scientifically or morally good or true. And I've seen this really on both sides of the traditional political aisle. On the left, it's a little bit more obvious. It leads towards these statements like anybody can be any sex is changeable, failure to protect unborn life, this extreme relativism where what you say is true for you, what I say is true for me. We deny this sense of an absolute truth. I think that's a lot more obvious on the traditional left. On the right, though, I do think it's still present, though more subtle. And what it leads to is a failure to address the actual moral and scientific merit of those same types of things. Just one recent example, I loved the outcome in the Chalice case. Colorado's conversion therapy ban clearly was not unconstitutional, or clearly was unconstitutional, excuse me. I loved the outcome in the case. But some of the statements made in the majority were a little bit questionable. I think, Frank, you might have highlighted some of these. There was a line disavowing, quote, prescribing what shall be orthodox in politics, nationalism, religion, or other matters of opinion. In Chalice, the majority said we can never prescribe what's orthodox in any of these categories. Well, what about the orthodoxy that it's wrong to kill unborn children, that it's wrong to try to change kids' sex and leave them physically and emotionally scarred? Yet another similar example. Last month, we covered a case in Texas where there's this group that puts on drag shows. They said that the state's ban on sexually explicit performances being done in the presence of minors violated the Constitution. In that case, the court eventually ruled against the group, but on a very technical free speech precedent where it kind of weighs the balances of these different applications of law. They said nothing about the fact that explicit performances like this can damage kids and expose them to the kind of moral bankruptcy that was once unthinkable in the United States. In this case we have right here in front of us, if we say that public officials have a constitutional right to put up whatever they want in their office, that could lead to some serious issues. What if a Satanist teacher wants to put up a display in their office? If we have no orthodoxy in religion or politics, how could we stop something like that? I know it sounds like a crazy example, but the exact thing happened in the Iowa State Capitol just a few years ago. Somebody put up a Satanist display with like a horned demon, and there was the claim that this is constitutionally protected right. Even more recently, an Indiana judge ruled that access to abortion is a religious right. So even on the left, like I said, it's a little more obvious, but even among conservative circles, this kind of refusal to weigh in on any moral substantive issue could lead to some serious problems. I know I'm straying a little bit into new territory here, and I want to be delicate. I certainly understand and can sympathize with the desire to prevent the government from making moral statements because I don't always think that they're going to be right. But it's an important conversation. If we reach the point where we bar all orthodoxy from our social virtues, we will end up with no social virtues. If, let's say, the government wants to say that We hold these truths to be self-evident. All men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That sounds like a political orthodoxy to me and a religious orthodoxy to me. And those words from the Declaration, if we reach this absolute truth skepticism and refusal to make any statement about what is right or wrong, those words wouldn't be constitutionally protected, even though they form the foundation of our country today. So, Frank, again, that's me straying a little bit into new territory, but I'd love to hear some of your thoughts on this case and maybe these conversations.
Yeah, no, it's a balancing act. I actually just published something. It'll probably be coming out right around when this podcast comes out, at the James Wilson Institute on the Childs case, on similar questions of what we're talking about here, what free speech is for. And obviously it's a tension, because on one hand, when my default is to be skeptical of government imposition of, you may do this but not that, or say this or not but not that. But it's not because of a skepticism about government per se. It's the skepticism about our current culture and government and elite leaders. I don't have a lot of confidence that they're enforcing what is true. But in theory, yeah, this idea, and it's you're right. The crux of it, I think, laid out well in the last paragraph of Justice Gorsuch's opinion in Childs, where he says, right, the First Amendment stands as a shield against any effort to enforce orthodoxy in speech or in expression, and that's it's not true. I mean, he seems to get at the reasoning. It's not just pure content, agnosticism, that like we are just free for the sake of being free. He actually says in the last sentence of that opinion, we've come to the conclusion that the best way to get to the truth is to have a free marketplace of ideas where the government doesn't interfere. And like, at least you get the idea that the end, like the purpose is to make sure that the truth isn't suppressed, not just have the freedom to do whatever. But I do think it's worth highlighting, and it's not beyond the pale to focus on that for a minute. That like this idea that the First Amendment exists to ensure that the government enforces no orthodoxy it's just obviously wrong. No disrespect to a Supreme Court justice, but I mean, one of the most glaring problems with that argument is there was a blasphemy exception to the free speech clause of the First Amendment. Like, it was, not only was blasphemy not protected speech, it was criminally prosecutable up into the 20th century. And what is that if not a government upholding of a certain orthodoxy, right? You're allowed to have religious plurality. You're allowed to have vibrant, vigorous disagreements about religion, but the malicious reviling of Christ was prosecutable conduct. So to say that the original like meaning and purpose of the First Amendment is to prevent the enforcement of any orthodoxy is clearly wrong. Like, every society has outer boundaries, which are orthodoxies, beyond which you cannot stray for the common good. That's just true in any society. You can't have a society that's just built on, we are all free to say and express whatever we want. That's just never the case. Find me a civilization where that has been the history, and I will back down, but that's not real. Humans can't function like that. And so, just to kind of bring this back around, right? In this case, the the result is good, right? Especially where our culture stands now, having the government come in and say, no, like, books about boys and girls being girls, that's just beyond the pale. Like, that's stupid. It's an offense against the truth about what a boy is and what a girl is, and there's no justification. So yes, practically, if you use like the free speech, free exercise, whatever avenue you use to make sure that people can say things that are true and good and harmless, by the way, and helpful in the public square, including to children, that's great. My only concern, again, is like you said, Joseph, if freedom from restriction is the end rather than like truth or goodness, then we have the opposite problem, that if somebody's putting up like weird sexually explicit pro LGBT materials in their offices and the kids are coming in, is that First Amendment protected? I mean, first of all, I would say that this is just bad, right? So even outside like the free speech jurisprudence, this is a problem. Then you have like obscenity issues, but let's assume that it's not obscene. Then you're right. Then we hit this tension between like, okay, we're just protecting things in the name of free speech that are ultimately extremely harmful to children and to society. And so this is a problem, because obviously the left has this dangerous issue of enforcing bad orthodoxies, like very dangerous ones, and suppressing truth. But on the quote unquote right, we have this problem of trying to act like we have no orthodoxies, like there is nothing that the government can ever say is true or good or false or bad, and that brings a different set of problems.
Yeah, absolutely. Just to wrap up my thoughts on where we are right now. There's that famous line from John Adams where our Constitution was made only for moral and religious people. It is wholly inadequate to the government of any other. Obviously, we want to be we want to have a legal system built on laws and not on men. We want to have impartiality and be able to kind of have the same outcome no matter who's sitting on the bench. But at the same time, this desire to strip any conversation about morality from these conversations, I don't think it's consistent with the founding of America, and I don't think it's consistent with human nature.
Yeah. Yeah, well, thank you for stopping me because I could definitely keep going there, but we will stray far beyond Napa Legal into the musings of Frank DeVito on political theory and the common good. So we will just pivot to our last issue. So this is just a quick update. I'm going to spend most of the time talking about the original case because I think it's good to remind people about how terrible and scandalous it was. Um, so this is was the I think the most prominent FACE Act arrest of a pro-life activist in during the Biden administration. His name was Mark Houck. If you don't remember it, he was arrested very dramatically at gunpoint in his house outside of the Philadelphia suburbs in September 2022. It was awful. His wife and all his kids were there. It was early in the morning and they came stomping in. It was like a SWAT team. Um, the alleged crime he committed was a violation of the FACE Act for assaulting an abortion worker. There's a lot to the story, but the history of the case was so wild that I want to remind the listeners about it because it was such an obviously targeted prosecution. There's more coming to light in recent days about the targeting of pro-lifers, and so I want to just take some time here to remind you of this case. So Mark Houck was a pro-life activist who would pray and counsel outside abortion clinics. He would regularly bring along his kids. He had a 12-year-old son at the time who would come with him. There was I think more than one altercation with this abortion escort, which I think are like adults that help women like walk into the clinic and avoid the pro-life people praying. I'm not really sure what they do, but it was somebody who was a volunteer for the abortion clinic, an adult man. So apparently depends whose story you hear, but from what I have heard, it's pretty well documented that this abortion escort, an adult, would like get into Mark Houck's son's face and say like weird, vulgar, inappropriate things to him about his father and what he's doing there and the pro-life movement. And so apparently, after this had been going on for a while, there was an exchange. Mark Houck shoved the man away from his son, and then there were all kinds of legal proceedings as a result. So a lot that I want to highlight here. One thing, the DOJ press release that came out in 2022, I think right after the arrest of Mark Houck, clearly didn't care too much about preserving the whole innocent until proven guilty thing, stated that Mark Houck twice assaulted the alleged victim because he was a volunteer at an abortion clinic. Think about what just happened there. Not allegedly assaulted, twice assaulted this person because he was a volunteer at an abortion clinic. So no presumption of innocence, but also a presumed motive, right? He shoved him because he was a volunteer at an abortion clinic. Why would he say that? This matters. This was very clever because you need it to create a federal charge out of what is not a legit federal incident. So the timeline here mattered. After the incident, right in 2022, the Philadelphia criminal authorities, who are that's the proper jurisdiction, right, for a local, matter of minor assault or whatever. So Philadelphia criminal authorities were contacted. They refused to press charges. Then there was a civil complaint filed by the abortion volunteer guy against Houck that was dismissed. So there's nothing there. And shortly after that, Mark Houck receives a target letter from the Department of Justice at the federal level, informing him that there's an ongoing federal criminal investigation. This is a common practice. Right before there are actual charges, they'll send you a courtesy letter saying you're under investigation. Houck's attorney attempted to contact the DOJ to discuss the situation and see what needed to happen to move forward. No response. And then a contingent of armed FBI agents came to his door. Wildly inappropriate. This is somebody whose attorney reached out and said, "Hey, what's going on?" Like, when your attorney reaches out, they'll say, "Listen, if there's if there's a charge, let us know. We'll cooperate so that the arrest and bail can happen in an orderly way. No response. And then these FBI agents kick in his door literally in front of his family early in the morning. So what in the world is going on here? Well, first of all, the only reason they could turn this into a federal crime that would justify FBI and DOJ involvement at all, because, right, feds have no jurisdiction to prosecute a civil, a local assault matter. This would be a state police power thing, and the federal government has no jurisdiction. But if you can claim that the motive is to obstruct an abortion facility, interfere with an abortion worker, right? Like we saw in the press release, the assumed motive. Then you invoke the FACE Act, and then it becomes a federal felony instead of what it was. But if Houck was just in an altercation, not because the man was an abortion volunteer, but because he was in his minor son's face saying inappropriate things, then there might be a question whether it's legitimate self-defense or assault. But it's a local matter, which Philadelphia refused to prosecute. Turning this into a federal charge is just such an abomination. It was so wildly inappropriate just from a legal perspective. Not even talking about the FBI's actions and the way that they went and raided his house as if he was some drug lord. Um, so the federal case goes forward. Houck was acquitted in 2023, I believe. After the acquittal, he filed a suit against the DOJ for malicious and retaliatory prosecution. It's interesting because the DOJ has a pretty good conviction rate. They don't. There was an article from Zeal reporting that their conviction rate is around 98%. When you're actually acquitted, it's a rare thing. Probably helped set up the settlement and give some evidence that this is perhaps a targeted political prosecution rather than a tight typical criminal case that the DOJ generally takes. Because if they had real evidence, then they probably would have had a real conviction. This is worth bringing back up, first of all, just because it's in the news that he got this settlement. So DOJ is paying Houck and his family quite a bit of money. But it also is timely because there was recently a 900-page report released showing that the Biden administration was pretty clearly weaponizing the DOJ to go after pro-lifers in particular. The report's really disturbing. It showed that groups like National Abortion Federation, Planned Parenthood, and the Feminist Majority Foundation actually worked with the DOJ in this process to target pro-lifers and prevent continued protest against abortion. The DOJ was in close contact with a lot of these groups. They used the communications with these groups to find out information about specific individuals who were protesting and who were activists against abortion, to shut down social media and even go after them with the FACE Act criminal prosecutions. So really crazy stuff. It obviously changed in the last administration. President Trump, thanks in large part to efforts by a lot of pro-life activists, including our friends at the Thomas More Society. Trump, in his first week in office in January 2025, pardoned, I think, all of the FACE Act pro-life prosecutions and convictions. It was like 10 or 11 pro-life activists who were pardoned, again, right after the inauguration. But that's good, and these things shouldn't shift with administrations. I'm pretty adamant that the FACE Act just needs to go. There are some legitimate uses of it to prevent, like restricting access to churches and things like that. But the FACE Act has been primarily used in practice as a tool to take simple trespass and assault and turn them into federal felonies to go after pro-life activists. It doesn't belong here. There's no real reason for it. There are already laws against trespass and assault for local authorities to go after them. So I'd like to see it repealed. Chip Roy, a representative from Texas, introduced a bill last year to repeal the FACE Act. I don't think that's moved. So I think the Mark Houck settlement is a good opportunity to bring this back into the media and put some more needed spotlight on the fact that the FACE Act still exists and that it's just an inappropriate vehicle to go after pro-lifers.
Yeah, Frank, thanks for explaining what's going on. From my perspective, this Mark Houck case or hack is probably the most cut and dry update of the week. These guys were praying outside of an abortion clinic. An older man approached his 12-year-old son, screaming at him and saying these vulgar things, and the dad stepped in to protect his kid. Obviously, we don't know what the actual facts were because none of us were there, but if that's how things went, props to him for protecting his child from somebody who looked like he was a serious threat. And in response to doing this, he was arrested by several armed FBI agents at his own home, even despite attempts to cooperate with an ongoing investigation. It's just an insane fact pattern. He was acquitted, but that's so clearly excessive force, and it's just a farce of a charge. So thank goodness he wasn't put in jail, and hopefully this settlement makes it clear that prosecuting pro-lifers in the name of this FACE Act won't go anywhere in court. right? The current administration has made some headway on reversing these previous attacks against pro-lifers, but legal action like this, especially really expensive and financially hefty legal action, is a bit more evergreen. It can last throughout administration changes. So hopefully cases like this show that when there's this insane prosecution, that's really just a farce of a case. It's not going to go anywhere, and actually, it's a likely constitutional issue, and you're going to get kind of countersued with serious penalties. So hopefully, yeah, this is a little bit more of an evergreen. It can survive administration changes, but certainly glad that this has kind of moved in the right direction.
All right. With that, I think we will wrap up and thank you to our listeners for joining us for this episode of the Napa Legal Podcast. So if you enjoy the content we're putting out, as always, we appreciate it if you like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you happen to be listening from. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. Until then, thank you for joining us and God bless you all.